So you finally got the licensing agreement and you're not quite sure what to do. You have to watch this video because there's some things in there that are going to be a little scary. There's going to be things in there you need to know how to negotiate. So please watch this video. Okay, everybody, I'm back with a good friend of mine, John Farrell. He's been my patent attorney for over 4 decades. John?
Let's go with 30 years. How about that? And 4 decades seems like a lot.
You guys, I have to tell you, my big idea was Spentformation, and John helped me create a wall of intellectual property that helped me fight against a very, very big toy company back in the day. And I cannot thank you enough, John, for doing that. Because intellectual property protection can be extremely important when you're dealing with big companies. But today we're going to talk about something a little bit differently, John. And you know I have a little experience at this, but I know you have a lot more than I do. Licensing agreements. Can you tell me a little bit about what they are and some of the sticky points about a licensing agreement?
So a license agreement is the transfer of rights between rights owners, and normally that's you, technology that you've come up with, Stephen, and someone who's willing to pay you for the use of that technology, either exclusively or non-exclusively. And just breaking down a license agreement. First of all, a license agreement is a contract. Normally, we want to have these license agreements in writing. They don't have to be in writing in all cases, but normally we would like them to be in writing. And in some cases, they have to be in writing if the terms of the contract are long enough or large enough. But there's 5 basic terms to every license agreement. And so I think a good place to start is just what are these terms? And these terms, the first 5 terms usually end up in something called a term sheet. And term sheet could be the back of a napkin or a 3x5 card. But these are the terms that the business owner or the rights owner typically negotiates. We don't want our lawyers negotiating the basic terms of a term sheet. So when you sit down for dinner or drinks with one of your licensees, and talk about licensing your technology, these are the 5 things that you want to kick around before you get the lawyers involved. First of all, what is it you're licensing?
Wait a minute. Before you dive in there, you just told me that don't bring your attorney in at the very beginning of a term sheet. Now, why is that, John?
Well, first of all, as a business owner, you want to drive the initial discussion and you want to keep it friendly. As soon as you bring in your attorney, there's a couple things that happen. First of all, everybody armors up. Everybody gets stressed when the lawyers walk in. Nobody's drinking when the lawyers are in the room, right? Also, the lawyers are hired guns and they want to earn their keep. And so oftentimes they'll posture just for the benefit of the client, right? Be tough, and that never helps the deal. It slows things down. Now there's a point where you're going to need the lawyers,
okay,
especially negotiating the fine print.
all right.
But at least as to the 5 basic terms, it's much better for the principals, for the business owners to negotiate these terms. First of which is, what is the license? What am I licensing? What is it, Stephen, in your technology that you'd like to have someone buy from you or use from you? The second is, when does it start, or when are you going to deliver the technology? When are they going to start using it? Third is, where is the technology going to be used? Is it going to be used in the United States? Is it going to be used in the state of California, Japan, another country? So where will the technology be used? How long is the contract going to last? That's the 4th term. Is this going to be 1 year, 6 months, 3 years, 10 years? And then finally, and you don't negotiate this one until you get the other 4 locked down, because this is the one where it doesn't matter until you understand the other 4 terms. And that's how much you're going to get paid. What's the license worth?
Okay.
And until you know what the first 4 terms are, you can't really negotiate a price. And what often happens is for the uninitiated, and I know this has never happened to you, but people jump into the price first. The first question for the licensee is how much do you want for it? And then you give them a price, and then they start negotiating the other four terms. And then you end up all twisted up. You go pretzel. So it's important to really understand what the licensee wants, what the scope of the license is, and then talk about how much.
John, I really like what you said there because you're right. Many times people just jump in and they want to know what type of royalty rate do you
Right.
want? But if you haven't seen the terms, like you just talked about, the four other terms or the licensing agreement, how can you possibly negotiate the price?
Right.
It's out of sequence. So I want to talk about that term sheet for just a minute. I don't like term sheets. Okay.
But you always use them. I know you do. You just don't think of them that way. But in your head, you've got the checklist.
Well, it is, and I try to make my checklist, I try to create what I call is the yes term sheet. I'm going to get yeses, so I get to the licensing agreement as fast as I can,
Right.
because I don't want to deal with some of the hard issues, the tough issues that we're going to talk about in just a minute, in a term sheet that could throw the deal out before you even got the licensing agreement. That's what I'm always afraid of.
If you get to yes on the first 5 terms, the other terms become a lot easier. In fact, you can let your lawyers deal with the other terms. And oftentimes you get to the price, you finish your drinks, you shake hands, and you leave. That's a high note, right? And by the way, sort of echoing your point, you kind of have to know what it is you want. When somebody asks you the question, what do you want? What do you want for your technology? You need to know. You need to know what it's worth. And so many times, and Stephen, I know you know this, but so many times, especially new inventors will say, well, I don't really know. I don't know what it's worth. And it feels so much like amateur hour for everybody. And it's especially hard on the licensee because, they would like to have a clear understanding of what the technology is worth and have a clear picture of how that value was derived. Okay, so let's talk about the conflict terms. I call these the conflict. These are the difficult. These are the things that go into the prenuptial agreement that get everybody stressed. We don't really want to talk about them. But the first conflict term is the indemnification and warranty. Who pays if someone gets hurt? Who pays if the product doesn't work as expected? And normally, as an inventor, and as a designer, and if you were to design a toy or you were to design a package, there is an expectation. You're not manufacturing, you're just designing. You do a prototype, and your prototypes are so beautiful and brilliant, but you do them with construction paper and tempera paint, and you send them over. It's up to the manufacturer to figure out, how they want to manufacture it. And if they're going to use lead paint instead of tempera paint, there's going to be liability there potentially that's not anticipated by you as the designer. How they manufacture affects the warranty. And so the discussion is who's going to be responsible if the product doesn't work out as expected. And sometimes it gets to the point where there's a lot of contention, and we can solve this often using an insurance policy. If we can't understand, if someone's not willing to price the risk in to their part of the agreement, then we can use an insurance policy to help us at least mitigate the risk.
Well, they're actually, I'm glad you brought this up because I had to bring you in on a situation a couple of years ago on this particular clause of indemnification. Usually companies that are going to be selling maybe to all the major retailers, they're required to have some type of product liability.
Right.
So that's a great thing. And you could maybe even ask to be on that policy, which I don't think costs them anything, but you're right. You can't be responsible for something you have no control over. But John, the other flip side though, is what are they asking us inventors to indemnify them?
Well, sometimes, sometimes it's something as simple as, will the product work? Sometimes is somebody infringing? If I manufacture this, will I be infringing someone else's intellectual property? And that's a harder question because there are some forms of intellectual property, copyrights, for instance, that you have to willfully copy and you have to have access and willfully copy. So you as an inventor could say, well, I can assure you, I can warrant the fact that this is not copied. This is my individual work. But with respect to an invention, sometimes you just don't know. I don't know if I was the first to invent this. I'm not going to warrant that this is patent or this is infringement free.
But they're asking me to do that. That doesn't seem fair. It seems like a too big of ask for me just to collect a royalty to be responsible for that. Is that true? And how do I navigate around that?
Okay, so a couple ways to do that. One of them is that both parties can decide whether they want to take that risk. And normally, I would say the manufacturer more likely takes the risk because they have the deeper pockets.
Okay.
They can fall into infringement just by virtue of by virtue of the steps they take in manufacturing. They can create infringement where infringement didn't otherwise occur. So normally it's easier and more efficient to the agreement for the manufacturer to take responsibility, to do their own due diligence.
Okay.
Is this a product that I want to build and can build and legally can build? And can I get insurance to cover any mistakes that we make in our due diligence? Now, it's possible to shift the burden of risk back onto the designer, the inventor. But often the inventor doesn't have the kind of deep pockets that would give very much comfort to the manufacturer in the event that there was a breach. For example, if you're building a bicycle and the bicycle sells for $500 and it contains pedals that were designed by an inventor and the inventor included his pedal design in the bicycle, he or she may only be receiving a few dollars for each bicycle sold. But the infringement liability on that bicycle could be treble damages on the manufacturing. And so it could be $1,000, $1,500 for every bicycle sold. Well, it would be unreasonable to ask the inventor.
So how do I go back and say that, John? Do I tell them that's unreasonable? It's only a 5% royalty, or maybe even a little bit less, or maybe even a little bit more. That's not appropriate. How do I say that?
Well, what's great about negotiating, a lot of people misunderstand how to negotiate.
All right.
If you negotiate from a place of transparency and you go to your manufacturer and say, look, dude, I'm being paid $3 a bike.
Okay.
I'm just an inventor. I got nothing. I have no equipment here except for a word processor and a printer. And if I get sued for patent infringement and you get sued for patent infringement, I'm not going to be able to indemnify you worth a darn.
Okay.
And if you're concerned about in patent infringement indemnification, we need to figure out how you can indemnify yourself and not rely on me because I got nothing. I'm not going to be in a position to give you the kind of comfort that you need in the event that there's a legal problem. And manufacturers get that. That would be irresponsible of them to say, hey, no worries, our inventor's got us covered.
I want to stop here for just a minute because this situation happened to me where this company wanted me to be responsible a little bit. And John, you gave me the best advice, the same advice you're giving now of being transparent and stating the obvious.
Right.
Look, if there's a problem, they're not going to sue me. I don't have anything. They're going to sue you. So
Right.
how do we work this out together type of thing? And that strategy has worked. And I cannot thank you enough for that. You guys, you listen to the guy that knows what he's talking about here because I've used this strategy with very big companies and it actually works. So John, you're spot on with that because it's a difficult thing to navigate, and sometimes we don't know how to overcome those negotiations. But I think you're right by just calling the elephant in the room a little bit here. And
And
it's
I think this is true with all negotiations.
okay.
Negotiations are not about hiding the ball. Negotiations are about letting each party know
Okay.
what's important to you. What are the things that you really need to have to get to a win-win? And as you know, Stephen, because you've spent your whole life negotiating deals, there's no art of the deal where one person wins and one person loses. If you can't get to a win-win, then
I know.
there's not going to be that relationship that'll support the deal after. It's, you know, the real test of a deal is what happens after you're in the deal and things go sideways, right? Because they always go sideways. Something always pops up.
John, they
And
do. Don't say that, but they do.
no, it's true. But if you have the relationship and you have
Right.
trust going into the signing of the deal, the execution of the agreement,
All right.
it's going to carry you all the way through to the natural termination rather than having a big blow up in the
All
middle
right.
of it.
What's the other ones you talked about?
Okay, so
What'd you call them? Would you call them
so
the
these are the four conflict terms, right? The four conflict terms. These are the deal busters. These are the four things that cause the most stress when negotiating a deal. And also, often you can bring your lawyers in to negotiate, not principal to principal, but let your lawyer call the other lawyer to work these terms out. The second one is improvements. Who owns the improvement? Let's say, for example, that you're working with a bicycle manufacturer and you have handlebar streamers. And you've come up with some new handlebar streamers that really decorate the bicycle. They look beautiful. And that's your life. You're bicycle streamer guy. And so the question comes up, and you have patents on your bicycle streamer. And the question comes up, okay, what if the bicycle manufacturer works with the bicycle streamers and improves them? Who owns the improvements? And that's an important term. Normally, the intellectual property is owned by the person who develops the property. So if you have an invention, you own your invention going into the deal. If the manufacturer comes up with a new invention, a new improvement on your invention, they own that improvement normally. If you do it together, if you invent together, then you both own, you jointly own that improvement. And that's a really horrible place to be, because if you jointly own the improvement, then either one of you separately can go and license to somebody else without getting approval, or we say accounting, that is, without having to pay the other person. So normally it's whoever invents gets the intellectual property. You may want to change that. You may not want your manufacturer to own intellectual property that is an improvement based on what you've designed.
Of
And
course
so,
I don't want them to do that, John. So what argument do I make in order for them to say, all right, Steve, you can own them all? Please help me with this one.
right. Well, first of all, if you have the underlying streamers, let's say you've built the handlebar streamers, you've designed it, you've invented them. They've come up with a new way of connecting your handlebar streamers to their bicycle, and they want to patent that. Well, their connection's not going to do a bit of good if they don't have your handlebar streamer patent to begin with. So that's your first line of argument. So if you make an improvement, I've got the underlying technology anyway, and I want to own your improvements, and I'm willing to price that into the deal. And of course, you'll automatically get a license
Okay.
to use your improvement. In other words, I'll license back to you my intellectual property on that improvement.
Okay.
That's one way to do it. But normally we just don't care. If the deal's rich enough, if they want to improve it, great, go do it.
All right.
So
Fair enough.
yeah, that typically works out. Okay, the third term, the conflict term, is term and termination. That is, how long, what are the causes that we can break up legally? And then how long does the deal last?
Okay.
And this is a little complicated because the reasons for breaking up are pretty obvious. They might be that mostly the reasons we break up is the contract isn't meeting our expectations in some important way. And that's very deal dependent. For example, if you go bankrupt as a manufacturer, I'm going to let you out of the deal. Or if the product is no longer selling and you don't meet a certain number of minimums, I'm going to either let you out of the deal or I'm going to force you out of the deal so I can go non-exclusive with some others. And then termination, how long does the deal last? This is tougher because if the deal's going well, as a technology owner, you'd like the deal to last a long time. On the other hand, if you feel like maybe you're not making as much per deal per unit as you would like, you'd like to have a shorter contract so you can renegotiate later once the product gets established.
All right. This
is really an MBA problem. You got to think a little bit about, okay, what's my future look like? It's like a sports athlete, how long do I make this contract for? Okay. Because I may be worth more later. And so that's a little harder. And then finally, the last deal term.
So John, wait a minute. Don't move on from that because this is really interesting. You're right. They're selling more. It's doing extremely well. I didn't cut the greatest deal at the very beginning. I didn't have any leverage, but now I want out. So do I make it a short term that doesn't just continue because of maybe they're hitting the minimum guarantees? What do we do to slip out?
Well, I think that, both sides, by the way, are running through the same calculus. Each side is trying to figure out what's best for them.
All right.
I think that for a small inventor, a longer deal is better. Right. There's stability in that, getting that mailbox money for a longer period of time.
Okay.
And time goes by quickly when all you're doing is once a quarter walking out to your mailbox and cashing that check, right?
All right.
Time goes by really quickly.
Okay.
A few years can go by, 3 years can go by really fast. Even 10 years can go by too fast if you're getting steady money. But you'll want to sit down and just think through what the upside is for stability versus being able to renegotiate later. And there's some possibility you could renegotiate later and there's no deal there. It could end. Right? Okay. So then the last conflict term is choice of law. And this is often blown up by the lawyers. It's fought over a lot by the lawyers, but honestly, it doesn't really matter because I don't think, because if you get to the point where you're arguing about whose law we're going to choose, you're in a bad place anyway. So choice of law means in the event of a lawsuit or in the event of a dispute, you're located in Nevada, for example. I'm located in California. Do we use Nevada law or do we use California law? And it might be that you're incorporated in Delaware, and maybe we just split the difference and say, okay, well, we'll go to Delaware if we have a dispute. A lot of contracts do that, or we'll pick some place in between. But it's generally good to let your lawyers deal with that because, for example, the law regarding forced arbitration is different in California than it is in Nevada. And so that may be important to you one way or the other, depending on which side of the contract you're on. So anyway, choice of law shouldn't be a big thing, usually pretty easy to compromise on that. But because lawyers are involved, it always gets writ large, if you let it.
I shouldn't just accept that I'm dealing with a company and they want to do it in their own state. Just, okay. Because sometimes I don't even pay attention to that.
Right. Well, if you have a lawyer involved, they're going to pay attention because my lawyers are not going to know Nevada law. And in fact, if it's interpreting the contract, I can't even look at the contract in the eyes of a Nevada judge and understand necessarily what the contract implies because I'm a California lawyer. So there are construction implications based on where you decide to fight the contract.
John, there's one thing you forgot that to me is important is the
Not
grant.
surprised, by the way.
Well,
Not surprised I forgot it.
well, there's one thing that bothers me, and I think I've got a solution to it, but I'd like to hear any advice you could possibly give us. The grant of license, you talked a little bit about that. And I want to keep it open. They want to tie it into some issued patent or maybe a claim. They want to narrow it down to why they're paying me a royalty for my innovation that has intellectual property on it. I want to open the door to where I get paid forever because I don't want to be tied to some patent that may issue, maybe it won't issue. I want to add new improvements. I want to keep that door open to stay to keep being paid for my work that I've done. In fact, I want to include in there maybe know-how or maybe goodwill or maybe I've done some other stuff to bring the deal together. Is that possible to do it that way?
So it is possible. Anything is possible contractually so long as it's legal. What you can't do is you can't tie your patent monopoly to something that's not otherwise legal to cover under that patent, because that creates antitrust issues. That is, for example, I will license you this patent for this one thing, but I'm going to require you to buy these other products. You agree to buy these other products that are not related to the patent, in exchange for the right to license my patent. So there's some time, it's called patent tying. So that's illegal. We have antitrust issues. It's a little complicated.
But let's say they are tied together.
But let's for example talk about know-how.
Okay.
So know-how has multiple components. First of all, there's trade secrets that are built into know-how. Trade secrets are fairly licensable, of course. Okay. You have things in your head that nobody else knows, and that they're valuable and they're worth money, especially in the packaging. Or you've been doing packaging for 40 years. You know packaging probably as well as any individual in the country, in the world, and that's valuable. So that know-how would be valuable. Also, even if the patent expires, that know-how continues to be valuable, provided that you continue to share the know-how or that the know-how remains valuable.
Okay. And
we look at know-how typically as a trade secret, and trade secrets, of course, remain trade secrets. Trade secrets are business advantages that you get by virtue of the fact that you know them and others don't know them. So trade secrets are licensable. So, and there's a couple of exclusions, so long as they're not public.
Got it.
So long as you didn't know the trade secret prior to having received it, or having received the trade secret from a third party who's rightfully in possession. So those are okay. As long as it remains a trade secret, then you're entitled to get paid for that. And I think that would be a fair thing to license. And by the way, your services also are licensable. So you can, and this is often a deal term that people overlook. But in addition to getting rights to my technology, I'm going to license you my patent. I'm going to license you my know-how, but I'm also going to license you access to me for a couple of hours per month, for which you will pay me separately.
Okay.
And that's going to be part of the license fee, is your right to ask me questions later. You'll pay me separately for those questions.
That's interesting.
But that's worth something.
Okay.
So even if the patent expires, you still have that right to access me.
John, thank you so much for this conversation.
It was my pleasure.
Yeah, I want to tell everybody, look, I do believe what John said at the very beginning of this whole process. You can probably navigate some of the big terms yourself, business terms, keep the lawyers out, fantastic, build that solid relationship. But at the end of the day, I'm going to tell you one thing you have to do. You need to bring a patent attorney or licensing attorney or someone to help you with that contract, because I'll tell you, it's very complicated. it can trip you up because the people that I've seen that have not brought in help, John, they always regret it. So I'm a big believer in using expert advice, expert attorneys such as John Farrell to help you to help you navigate the tough issues. John, thank you so much. That's all I have to say. You've been great for me over 30 years. I appreciate everything you've done for me.
Oh, my pleasure, Stephen. Keep after it, man. You're doing great. Talk to you later.
Thanks, everybody.
If you're not sure about this and you need a little help, please give us a call. We have a program called Gateway where we do everything for you. We know how to reach out to the right companies. We know how to reach out to the right people. We know how to make sure your marketing material is communicating correctly so they can look at it, they can make good decisions. We know what questions they're going to ask, and we can be prepared for those questions in advance. And when that licensing agreement comes over, we can help make sure it's a fair and balanced licensing agreement so everybody's happy. Basically, we're doing all the work for you. It's our program called Gateway, and if you need help on any of this, please pick up the phone, call us, and let's see if Gateway is right for you.